let me give you a little bit of data. The recommendation is to revise the definition of administrative probation, which would allow the Department of Corrections to focus its resources on high-risk offenders. The real gist here is to more closely or more clearly delineate the responsibility of the Department of Corrections relative to administrative probationers. And the data is this. George, the population of probationers in Georgia has grown 29% in the last 12 years. We have 164,000 probationers with approximately 10 million people in this state. Comparatively, Florida has the same number of probationers, 165,000 probationers, with 19 million, nearly twice as many citizens in that state. We don't compare very favorably based on number of probationers versus the number of citizens. Part of that growth in Georgia is due to the length of probation sentences. In Georgia, probation sentences are nearly twice as long as the national average. 6.83 years is the average length of probation in Georgia compared to 3.2 years nationally. We have very, very lengthy, comparatively long probation sentences. The national standards for supervision for your active probation caseloads are as follows. For your special offenders, those are those that are on intensive probation supervision, sex offenders, and those in a day reporting center, is 20 to 1. That ought to be the ratio as between probation officer versus offender. 20 to 1. In Georgia, the current numbers are 58 to 1. For high risk offenders, the number on average, the national standards suggest that the number should be 50 to 1. We're at 58 to 1, so we have a little worse ratio there. And on standard probationers, the national average is 200 to 1, and we're at 287 to 1. As you all may remember, in 1992, this General Assembly addressed length of probation for the last time. It has not been addressed since then. And at that time, we promulgated statutes that allow an offender after 2 years of satisfactory supervision on active probation to be removed to administrative probation, where the obligations of the offender are less. We have roughly 63,000 offenders in unsupervised or administrative status in Georgia, 63,000. Of those, the recidivism rate for those as compared to active probationers is quite marked. The 63 offenders have a recidivism rate of 18% of rearrest, not probation violations, versus 60% for active probationers. In short, and the Commissioner of Corrections is here if you have any specific questions, but in short, as presented to the Council and as considered by the Council, there are a myriad of obligations that probation officers have for this class of administrative probationers. You might not think that there's much that a probation officer has to do because administrative probationers are relieved of an obligation to report to a probation officer. There are many things probationers do not have to do as a result of being on administrative probation, which again is authorized after 2 years of active probation. But one of the problems we have is under the Interstate Compact, as the 63,000 inactive but administrative probationers in Georgia wish to move, for example, they have to apply to their probation officer years later, while they're still on probation but on administrative probation, for permission to move under the Interstate Compact. And paperwork has to be filled out, and there are a lot of obligations that these probation officers have vis-a-vis the administrative probationers that takes time away from dealing with the offenders that really need the supervision, and that is predominantly your special sex offenders and intensive probation offenders and your high-risk offenders. And so we're really not suggesting in our recommendations, nor is what is included in lines 339 and 347, that we do anything other than change that term administrative probation to unsupervised probation, which under the Interstate Compact would allow, as I understand it, more clearly delineate the role of corrections relative to compliance with the Interstate Compact and a couple of other things. It does not really change the status of that offender or the obligations of that offender, nor would it change, for example, that if while on probation, administrative or otherwise, that offender committed a crime, there's going to be a detainer placed on that offender, and the issue of revocation of probation will still be eligible for the court to consider. But this is basically an opportunity to alleviate some of the obligations, non-consequential, quite frankly, obligations that corrections has. You should be aware that there are significant costs associated with getting up to standards, if you will, for supervision levels. If you do nothing, based on anticipated growth of Georgia's prison or probation population, which is now at 164,000, To come within the standards of supervision as promulgated by the National Probation Association, you would need approximately 204 officers at a cost of about $11 million. And so this is an opportunity without fiscal impact to shift some of that responsibility so that these offenders can be supervised and our limited resources in the nature of probation officers can be targeted to the most serious needs.